As you know, administrative action must, in terms of Section 33 of the Constitution, be lawful, reasonable, and fair. One of the requirements of fairness is that administrative action must be taken by an impartial or unbiased decision maker. And you can imagine why this is so. Imagine there's a referee in a soccer match or a rugby match who clearly favors one side and who's a known supporter of one side. Would you feel that the soccer or rugby match was being refereed fairly? Of course you wouldn't. And for that reason, there's a requirement in administrative law that administrative action must be fair, as in unbiased. Now, the rule against bias was first articulated during the common law through the Roman maxim nemo iudex in sua causa, which basically means one should not be a judge in one's own case. In other words, a decision maker, when making an administrative decision, must approach each decision with an open mind, without having, for whatever reason, prejudged the matter. Now, this rule against bias operates in both a prospective and a retrospective fashion. First, should a person who stands to be affected by an administrative decision suspect that the decision maker is biased, he or she may request that the decision maker recuse himself. In other words, allow someone other than himself to take the decision, so as to remove any suspicion of bias before a decision has been made which would be tainted by bias. Secondly, should an administrator suspected of bias refuse to recuse himself and proceed to take a decision, or should a person affected by a decision already taken then suspect that it was biased, the prohibition against bias operates as a ground of review of that decision after the fact. A second thing that the rule against bias entails is that the administrator must not be perceived to be biased, nor must he be actually biased. And we'll unpack that in a moment. The final thing to note for now is that bias doesn't necessarily entail corruption. Rather, it connotes a prejudgment of a matter. Hoekster, at page 454, gives some examples of different sources of bias. So the first example she gives is that of bias arising from a financial interest in a matter. And she speaks about the Rose case, where the chairman of the transportation board also happened to be the director of a taxi company. She says that when the board refused an application for an exemption certificate in respect of car hire services, it was held that the chairman's interest in excluding competitors would include an apprehension of bias in a reasonable person. So in other words, the chairman of the transportation board created a reasonable apprehension of bias by the fact that he had a financial interest in a taxi company. The second source of bias that Hoekster speaks about is a personal interest. Famous cases that Hoekster refers to include a situation where a license was granted to the brother of a mayor, and it was found that because the mayor had sat as a member of the board that determined the license application, the decision of the board was tainted by bias because the mayor had a personal interest in giving the license to his brother. Hoekster explains that bias can also occur if someone associates himself with one side of a dispute. This is what she refers to as bias on the subject matter. She speaks about the Mafungozi case, where members of a disciplinary tribunal also sat on the appellate body, thus effectively hearing an appeal against their own decision. They had aligned themselves with one side of the dispute and couldn't be impartial at a later appeal hearing. In the apartheid era, it was quite common for racial prejudice to create bias on a subject matter. So Hoekstra references the Patel case, where a mayor said that he would move heaven and earth to prevent an Indian from acquiring a dealer's license outside of the Asiatic Bazaar. So the mayor aligned himself with a particular subject matter which would make it impossible for him to decide an application for a license in a fair manner, a fair and particularly impartial manner. The final kind of bias that Hoekstra identifies is official or institutional bias. Institutional bias occurs where a decision maker is biased as a result of institutional factors rather than their personal characteristics. So she gives the example of the Dumbu case, where prison warders complained about discrimination against black prison officials, but their complaints were persistently ignored or stifled. The warders then engaged in strike action in order to highlight the issue of discrimination, and the officer appointed to preside over an inquiry into their conduct was the head of the personnel department, who would have almost certainly have participated in the suppression of the warders' complaints in the first place. So his institutional bias towards the position of the prison to discriminate against black prison warders would prevent him from being able to adjudicate the black prison warders' dispute or charge against them in a fair or impartial manner. So in other words, institutional bias refers to an alignment with the views or policies of the institution to such an extent that it's simply not possible to determine the outcome of a dispute within the institution in a fair or just manner. Let's then turn to the difference between actual and perceived bias. As I mentioned earlier, the rule against bias prohibits both actual bias but also perceived bias. There are a couple of reasons why both actual and perceived bias should be regulated by the rule against bias. The first is that practically it will not always be possible to prove that someone is actually biased. In other words, to show that in their mind they see things in such a way that they cannot adjudicate an issue in an impartial way. And this is because bias also occurs not only consciously but also subconsciously. Often, bias will lie in the subjective state of mind of the administrator. So for this reason, someone who is perceived to be biased may also be found to have acted unfairly, even if they're not actually biased. A reason for this is also that, in principle, justice must not only be done, but must be seen to be done. This is because the public trust in the fairness of governance and the administration depends not only on whether it is actually fair, but also on whether it is perceived by the public to be fair. So when actual bias exists and can be proven, obviously it will be capable for someone to raise as a ground of review in terms of Pudger, particularly section 6.2a.3, that the administrator who took the decision, was biased. But typically, there will be no proof of actual bias. So we need to understand when someone will be able to review and set aside a decision on the basis of a perception of bias. So we need to understand now, in our constitutional era under PBL, how it is that one can use section 6.2a.3 so as to raise on review that an administrator was reasonably suspected of bias and use this ground of review to set aside a biased decision. And in order to work this out, we need to look to a pre-constitutional era case that is really the basis for the current test for a suspicion of bias in our law. The case is BTR Industries, which we'll describe in a moment. For now, it needs to be understood that the test for a reasonable suspicion of bias, in other words, a perception of bias, is that there must be sufficient grounds such that a reasonable person would suspect that the administrator might be biased. So the test is a reasonable suspicion or reasonable apprehension of bias. The test is an objective one. The question is whether a reasonable person would, in the shoes of the complainant, have a reasonable suspicion or apprehension that the administrator might have been biased. So the test isn't whether the administrator was biased, but whether the administrator might have been biased. If a reasonable suspicion of bias exists, then it's open for the person aggrieved by a decision to take it on review in terms of section 6.2a.3 of PBL, and the likelihood is that the decision will be set aside as invalid on the basis of a reasonable suspicion or apprehension of bias. Let's now look at how practically this test works with reference to an apartheid era case called BTR Industries. BTR Industries involved a labor dispute between an employee and an employer. Now remember that before the constitutional era, labor issues were also resolved on the basis of administrative law. This is no longer the case because there's a separate body of labor law, but the case is useful as it illustrates how the test for a suspicion of bias was developed, and the same test is still used today. So there was this dispute between an employee and an employer, and the matter ended up in the erstwhile industrial court, which was an administrative tribunal. The presiding officer was a senior practitioner in labor matters. Shortly before the hearing between the employee and the employer, he had been invited by a labor consulting firm to present a paper at a seminar. The labor consulting firm was an advisor to the employer and in a partner-type relationship with the employer. The labor consultant had demonstrated a very hostile attitude towards the union representing the employee in the dispute. And during the course of the proceedings between the employee and the employer, the presiding officer presented this seminar. The employee's representative asked the presiding officer to recuse himself then from the hearing of the dispute between the employer and the employee, but the presiding officer refused. The presiding officer ultimately found against the employee, who took the decision of the industrial court on review. The court then developed the test for a reasonable suspicion of bias. The court said that there may not merely be a simple allegation of bias, but there must be a reasonable ground for the suspicion of bias. The court highlighted that the test for a reasonable suspicion of bias is an objective one and turns on whether a reasonable person in the shoes of the complainant would have a suspicion of bias. That is, would have a suspicion that the administrator might be biased. The test is not, therefore, whether there was a suspicion that the administrator was, in fact, biased, but rather that he might have been biased. The court said that here, the presiding officer had accepted an invitation to speak at a seminar and had spoken at a seminar when it was organized for a consulting firm who advised the employer in the dispute and who was in a partnership type relationship with the employer. The court, therefore, when reviewing the decision of the industrial court, found that there were reasonable grounds for a suspicion of bias. Even though the presiding officer did not speak about the dispute in issue at the seminar or discuss that issue with the representatives of the employer, it was possible that he might have been biased. So, applying the reasonable suspicion of bias test, the court said that although there was no proof of actual bias, there were sufficient grounds for a reasonable person to apprehend that they might have been biased, and so the court set aside the administrator's decision. Now you should be able to apply this test in other circumstances, so when other sets of facts arise, and you should understand how the reasonable suspicion of bias test works. The final thing that you need to note about bias is that the Constitutional Court has, in the constitutional era, reformulated the test for a reasonable suspicion of bias as a reasonable apprehension of bias test to do with the aspersion or the idea that bias is necessarily corrupt or warrants suspicion, as opposed to being about merely prejudging the matter. Of course, one way in which a matter can be prejudged is if there's corruption that warrants suspicion, but that is not the only way in which a prejudgment can arise, as hopefully you've seen through the examples given during the course of this short video. Thank you.